Hi, Lecture 10 will be on Union and Industrial Relations Process, and we are going to focus on industrial actions and conciliation and arbitration. There are 3 rules and regulations to make sure that the industrial harmony can be achieved in Malaysia. Number 1, we have the Industrial Relations Act 1967. It is an act to promote and maintain industrial harmony and to provide for the regulation of the relations between employers and workmen and their trade unions, and the prevention and settlement of any differences or disputes arising from their relationship, and generally to deal with trade disputes and matters arising therefrom. And then we have the Trade Unions Act 1959, which is an act relating to trade unions. The third one is the Code of Conduct for Industrial Harmony. The Code of Conduct aim is to lay down the principles and guidelines to employers and workers on the practice of industrial relations for achieving greater industrial harmony. What are industrial actions? Industrial action includes any temporary suspension of normal working arrangement initiated by employees or management with the aim of exerting pressures within the collective bargaining process. Trade dispute means any dispute between an employer and his workmen which is connected with the employment or non-employment or the terms of employment or the conditions of work of any such workman. Industrial action works as a mechanism to challenge, argue, or question the prevailing social system. It looks at the relationship between individual, groups, and institutions. It is also important as a precursor to the creation of a new social order, the way in which society is organized. It can be new rules or way of how people should behave or act. Apart from that, industrial action works to maintain or regulate social order through open expression of conflict. It provides the means to identify differences and ways to resolve it. Industrial actions usually occurs due to individual grievances, disputes on terms and conditions of employment, disputes relating to interpretation of collective agreement, non-implementation of collective agreement or award, and the refusal to commence collective bargaining. These are the different forms of industrial actions or industrial disputes. It can be performed either by the employees or the unions, and then the employer or the management, and then even by the unorganized individual action. So for the employees, they can perform sit-in or work-in, withdrawal of cooperation, overtime ban, go slow, work to rule, picket, and also strike. And as for the employer or management, they can perform unilateral imposition, suspension or other disciplinary actions, hire replacements, closure of works, and also lockout. As for the unorganized individual action, the types of industrial actions that can be performed can be lateness and absenteeism, accidents, labor turnover, and also legal action. Now we are going to look further into the forms of industrial actions or disputes in Malaysia. Number 1 is picket. So picket is a form of peaceful gathering with more than one person conducted near or around the place of employment where a dispute had occurred. Picket is provided under Section 40 in bracket 1 of the IR Act 1967. The main reason for picketing is to communicate information to the public about the problems in the workplace without damaging any property or without causing disorder or without preventing any entry to and from the workplace. Among the methods in picketing can be in the form of posters, banners, placard, or any written materials containing grievances, problems, and any issue relating to the dispute. Sometimes media is also used to provide more effective force or pressure to employers to accept the demands. There are several rules in picketing. Number 1, it should be conducted as a result of trade disputes For example, the failure of organizing collective bargaining. And then the picket is done near or around the workplace and not inside the workplace. It is also must be done in a peaceful manner without causing any disorder, and it cannot be chaotic. Picketing must be done outside of working hours, which is before or after office hours or even during lunchtime. Picketing is not organized or joined by any other person other than members of the trade unions. The second form of industrial actions or disputes in Malaysia is go slow. It is an action of deliberately delaying the production process in a factory. Employees are working without enthusiasm and at a lower level of performance output than normal. Go slow is not defined under any of the acts in Malaysia. Next is work to rule. It is strictly interpreting the duties specified in the contract of employment, collective agreement, job description, or other rules and requiring precise instructions from management regarding the execution of work. This is when employees deliberately following strict rules of working hours. Work to rule is not defined under any of the acts in Malaysia, just like go slow. And then we have strike, which is temporary withdrawal of labor and stoppage of work. Strike means the cessation of work by a body of workmen acting in combination or a concerted refusal or a refusal under common understanding of a number of workmen to continue to work or to accept employment, and includes any act or omission by a body of workmen acting in combination or under common understanding, which is intended to or does result in any limitation, restriction, reduction, or cessation of or dilatoriness in the performance or execution of the whole or any part of the duties connected with their employment. Collective action of employees in strike involves cessation, refusal, restriction, limitation, reduction, and also delaying work. They either delayed all or part of the work process. It is more aggressive than picket because of the financial implication. Strike may incur financial or property loss. Strike may distract or cease the production process as well. Strike is the last resort taken by the trade unions to force employers to accept their demands. Among the methods for strikes can be mass gathering at the workplace. They can even go slow, being absent to work, or even refuse to go to work. Strike can only be conducted by a registered trade union. The issues are a result of a trade dispute, and the trade unions must conduct secret ballot prior to strike. In conducting secret ballot, the ballot must receive 2/3 of eligible members, and the result is only valid for 90 days and shall contain the following, which are the issues, the reasons for the strike, types of actions to be taken, and types of actions not to be taken. The result of the secret ballot must be submitted to the Director General of Trade Unions and the state within 14 days from the date of the ballot taken. This is under Section 40 in bracket 5 of the Trade Union Act 1959. Strikes can be prohibited if the secret ballot failed to get 2/3 majority of its members. Strike cannot commence before the expiry of 7 days after submitting the result of a secret ballot to the state. Strikes is also prohibited if the secret ballot has become invalid, and it must not be done if it is against the rules of the trade union. Strikes is prohibited in respect of any matter covered by a direction or decision of the minister given or made in any appeal to him under Trade Union Act 1959, and in contravention of or without complying with any other provision of Trade Union Act or any provision of any other written law. Next, we are going to look at the procedure of strike or lockout in essential services. So essential services are any services listed in the first schedule of the IR Act 1967, such as bank, electricity, fire, postal, prison, etc. For essential service, there are additional rules required before a strike can be declared. Number 1, trade union must give 42 days notice to the employer before the strike is declared. And then, the strike cannot be declared within 21 days from the date of the notice given to the employer, and the strike cannot be declared before the expiry of such notice. Lockout is another form of industrial actions or disputes in Malaysia. Lockout is the exclusion from work by employers of employees engaged in labor controversies. Lockout means the closing of a place of employment, or the suspension of work, or the refusal by an employer to continue to employ any number of workmen employed by him in furtherance of a trade dispute, done with a view to compelling those workmen to accept terms or conditions of or affecting employment. Lockout is an action commonly taken by the employer or trade unions of employers after employees' unions launch a strike. The purpose is to force employees or trade unions to accept the rules relating to employment. There are three precursors of lockout. Number 1 is the trade unions of employers must be registered under the Trade Unions Act 1959. Reasons for lockout must be a result of a trade dispute, and the trade union of employers must conduct a secret ballot prior to lockout. As for the procedure of lockout, the trade unions of employers, 2/3 must agree to the lockout. The secret ballot is only valid for 90 days and shall contain the following: the resolution to declare lockout, reasons for lockout, types of actions to be taken, and types of action not to be taken. The result of the secret ballot must be submitted to the Director General of Trade Unions within 14 days from the date of the ballot taken. Lockout cannot be declared before the expiry of the 7 days after submission of the result to the Director General of Trade Unions. Now we are going to look at the procedure for lockout in essential services. So again, essential services are any services listed in the first schedule of the IR Act 1967, such as bank, electricity, fire, postal, prison, etc. For essential service, there can be additional rules required before a lockout can be declared. The trade union of employers or employers must give 42 days notice to their employees. The lockout cannot be declared within 21 days from the date of notice, and the strike cannot be declared before the expiry of such notice. Either strikes or lockout are prohibited if it is pending, during or within 7 days of the result of the investigation of a board of inquiry. It is also prohibited when the dispute has been referred to the industrial court and when the Yang di-Pertuan Agong or the state authority has not given a consent for the dispute to be referred to the court. Strikes and lockout are also prohibited on matters covered by the collective agreement after it has been recognized by the court and on matters relating to management prerogatives. Strikes or lockout is considered illegal if it is contravening or against Section 43 and Section 44 of the IR Act 1967 and if it is not related to any trade dispute. There are two elements that must exist before a trade dispute can be declared in Malaysia. Number 1, it must be between the relevant parties. And then second, the subjects or issues must be related to employment or non-employment, terms and conditions of employment or work rules. There are 4 main issues in a trade dispute. The first one is employment. For example, the job description, duties, responsibilities, work processes, status of designation, authority, work-related risks, work performance, etc. Some of the issues are subject to management prerogative. And then we have the non-employment. For example, the dismissal, termination or retrenchment benefit, suspension, etc. For issues pertaining to dismissal, it should be dealt under Section 20 since 1989. Third is the terms and conditions of employment, which includes the terms and conditions in the employment contract or collective agreement, for example, whether it is express, implied, monetary, or non-monetary. The existing benefits is an example of an implied term of conditions of collective agreement. It may involve any monetary or non-monetary benefit which have been the common practice of the company. Next is the condition of works. For example, the utilities at the place of employment, office equipment, for example, table, chairs, work equipment like the stationaries, and even the space or office layout. So when is trade disputes considered to exist? IR Act 1967 does not clearly outline when trade disputes considered to exist, except in Section 13, in bracket 7, the refusal to collective bargaining. When one of the party refused to collective bargaining, then trade dispute can be considered to exist. Other disputes are not clearly spelled out in the Act. Methods of dispute resolution under IR Act 1967 can be classified into three. The first one is bilateral negotiation between employers and employees or trade unions according to the procedure as agreed in the collective agreement. And then it can be done through conciliation by the Department of Industrial Relations, Ministry of Human Resources, and also through arbitration by the Industrial Court. Bilateral negotiation is based on self-government in industry, where both parties are encouraged to resolve disputes through negotiation to achieve an amicable outcome. For conciliation, it is an effective method to resolve dispute. It involves several meetings between employers, employees, trade unions. The meetings are normally conducted jointly and sometimes separately between parties. When conciliation fails to resolve the dispute, the Department of Industrial Relations will notify the Minister. The Minister has the authority to take necessary steps to resolve the dispute. The Minister may refer the dispute to the Industrial Court either at the joint request in writing by both parties or on his own motion. The Minister may exercise his discretionary power to either refer or not the dispute to the Industrial Court for arbitration. As for the arbitration by the Industrial Court, the Industrial Court only has the authority once the dispute is referred to it by the Minister. The Industrial Court power or authority to hear the dispute comes under Section 30 in bracket 1 of the IR Act 1967, and the decision is binding on both parties.